Good afternoon. I'm still reporting on the coup. This is the first big break in the cruel, illegal persecution of the January 6th protesters. The Supreme Court of the United States, or SCOTUS, announced today that it will take up a defendant's appeal to a novel legal theory that the Justice Department used to slam many J6 protesters with unusually harsh prison sentences. This novel legal theory is so novel that this reporter admittedly still doesn't understand the supposed logic behind it. The most widely charged felony in the J6 cases is based upon some version of evidence tampering law, which was used to charge hundreds of J6 defendants with felonious behavior that carries up to 20 years in prison. Even the premier newspaper in the United States today, the Epoch Times, explained only that the court agreed to hear the petition of Joseph Wayne Fisher, charged with corruptly obstructing an official proceeding, namely a joint session of Congress convened for the counting and certification of Electoral College votes on January 6, 2021. But they don't or can't explain how evidence tampering fits into this picture. However, they do go on to explain that the DOJ had charged nearly 330 defendants and former President Donald Trump with obstruction as of December 6th. Marina Medvin, a defense attorney who co-authored a friend of the court brief supporting the challenge of the DOJ's prosecutors, said that the vast majority of the cases at issue should never have been felonies. She also explained what the impact on the defendants, most of whom had no previous criminal record, would be. If the case turns in favor of the defendants, this will be life-altering for hundreds of people who were unjustly persecuted for a felony offense instead of the misdemeanor that it was crafted by Congress for the trespass behavior at issue. Another defendant, William Pope of Topeka, Kansas, said, "The Supreme Court taking up the obstruction of an official proceeding appeal is a clear message to the DOJ that governmental extremism has gone too far, that more than 300 Americans, including President Trump, myself, and many currently in prison, were wrongfully charged." Pope also pointed out that the DOJ has used the possibility of 20-year prison sentences to bully many of the defendants to accept imprisonment for pleading guilty to prison sentences of shorter duration. The outcomes of many cases would be far different if not for this DOJ malpractice. Only one D.C. judge has thrown out the made-up DOJ charges, U.S. District Judge Carl Nichols. He wrote that the applicable statute does not apply to these J6 defendants because there is no evidence of tampering, which requires that the defendant have taken some action with respect to a document, record, or other object in order to corruptly obstruct, impede, or influence an official proceeding. It seems that the Supremes have decided to hear the case because they have yet to take any concrete action against an in-your-face authoritarian coup d'etat effectuated by those with financial ties to Communist China. Let's hope that this will be only the first example of them asserting their significant constitutional responsibilities to be a balance against the runaway defiance of the rule of law exhibited by the current Justice Department. I'm still reporting from just outside the citadel of world freedom. Good day.